Hello, and welcome to Coast Legal Aid of South Florida's Legal Learning. Today, we're going to talk about the types of injunctions available in Florida. A couple of disclaimers. This presentation is not intended to provide specific legal advice, and the information is current as of July 21st, 2022. The 5 main types of injunctions for protection in Florida are domestic violence, dating violence, sexual violence, stalking, and repeat violence. And so if you feel that you've been the victim of any of these types of violence, you can file a petition for an injunction for protection and ask the court to grant you protection from the abuser. This also includes what's called OBO petitions, and that stands for on behalf of. And typically those are on behalf of minor children. So any of these types of injunctions, you can also file on behalf of minor children. First, we're going to talk about injunctions for protection against domestic violence. So the first thing that you need to know is that it needs to be filed by somebody in a domestic relationship. And the way that the law defines a domestic relationship is a spouse, which can be a current spouse or a former spouse, could even be separated, related by blood or marriage, residing together as a family, and that does include same-sex partnerships, and unmarried couples who have a child in common, regardless of if they ever lived together, if they're currently living together, or never lived together. The definition of violence for domestic violence is any assault, aggravated assault, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense that results in a physical injury or death of one family or household member by another family or household member. And so what we recognize as advocates for victims of domestic violence is that this may not encompass everything that domestic violence is, but this is the legal definition. So it does not include things like psychological abuse or emotional abuse, financial abuse, or controlling behaviors. So it does need to be an act of violence that does fall under the legal definition. Who has standing to file is who can actually file for an injunction for protection. And the person must either be the victim of domestic violence as defined by the law, or they have to have reasonable cause to believe that they are in imminent danger of becoming the victim of one of these acts of domestic violence. And again, you can also file this on behalf of a minor child. The next type of injunction that I'm going to discuss is an injunction for protection against dating violence. And so this is typically people who have been dating. And the law defines the dating relationship based on 3 factors. So the dating relationship had to have existed within the last 6 months before filing. The nature of the relationship had to be characterized by the expectation of affection and sexual involvement. And the frequency and type of interaction between the 2 people involved in the relationship had to have been involved over time and on a continuous basis during the course of the relationship. So these are people who had a continuing and significant relationship of a romantic or intimate nature. And this doesn't include people who were involved in casual acquaintanceship or, regular coworkers or people involved in business or seeing each other at parties. This has to have been an actual relationship. So for dating violence, they use a definition of violence, which is very similar to the domestic violence statute. So this again is an assault, an aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, or false imprisonment, or any other criminal offense that results in a physical injury or death by a person against another. And who can file this? It could be filed by the person who is the victim of dating violence, who also has a reasonable cause to believe that they are in imminent danger of becoming the victim of another act of violence, or any person who has a reasonable cause to believe that they are in imminent danger of becoming the victim of an act of domestic dating violence, or the parent or legal guardian of a minor child who is living at home. And so we do see this many times, unfortunately, with parents who do need to file on behalf of their children who have a dating relationship with somebody and it has become violent. Sexual violence is another type of injunction that you can file for protection from. And the definition of sexual violence in the statute does reference some of the other statute, but basically you only need one incident of sexual violence to file, and it will have to be an incident of sexual battery, lewd and lascivious act committed upon or in the presence of a person younger than 16, luring or enticing a child, sexual performance by a child, or any other forcible felony wherein a sexual act is committed or attempted. And the statute does also state that this is regardless of whether criminal charges based on the incident were filed, or if they were filed, whether they were reduced or dismissed by the state attorney. So who is standing to file for an injunction for protection against sexual violence? It would be any person who is the victim of sexual violence or the parent or legal guardian of a minor child who is living at home, who is the victim of sexual violence, can file. So they can file on their own behalf or on behalf of the minor child if that person has reported the sexual violence to a law enforcement agency and is cooperating. So making the report about sexual violence is considered cooperating. Whether or not any types of criminal charges get filed either by law enforcement or the state attorney's office, or if they are filed, if they end up getting dismissed or reduced, you can still pursue an injunction for protection. And then there's an or here, and the or is for people who have been victims, or it's the parent or legal guardian of a minor child who was a victim, and the respondent had been imprisoned for sexual violence, and the term of imprisonment is set to expire or has expired. And you can also file for an injunction for protection in that case. There's also an injunction for protection against stalking, and the injunction process is a civil matter. It's in civil circuit court, and it uses the misdemeanor definition of stalking for the injunction for protection. So this would be a person willfully, maliciously, and repeatedly following, harassing, or cyber stalking another person. That's the misdemeanor definition. So the court's going to look at whether the respondent engaged in a course of conduct directed at a specific person, the petitioner, which causes the petitioner to have substantial emotional distress and serves no legitimate purpose. And so when you look at what would be the course of conduct, it would be a series of acts over a period of time. And the law doesn't necessarily define in the statute how long that period needs to be, but there is some case law on it. But basically, sometimes it could be as short as a 90-minute period, but there has to be this pattern of conduct. And there's also a note that it does not include constitutionally protected activity, things like protesting or picketing. That is not going to be considered stalking by the court. That's a constitutionally protected activity. There's also repeat violence, which is almost like a catch-all. This is, there doesn't necessarily have to be a relationship between the people. We see repeat violence injunctions often with neighbors or coworkers. And this, for repeat, obviously has to have more than one incident, and you need at least 2 incidents of violence or stalking. And one of those incidents has to have been committed within the past 6 months before the filing of the petition. The incidents also have to be directed either against the petitioner or the petitioner's immediate family. And again, violence is defined as assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping or false imprisonment, or any criminal offense that results in a physical injury or death. There are a few other types of injunctions for protection in Florida. One is the risk protection order, and this came out after the Marjory Stoneman Douglas tragic school shooting. And the Florida legislature passed the Marjory Stoneman Douglas High School Public Safety Act. there is included a risk protection injunction. And this is so that law enforcement can restrict firearm and ammunition possession by someone who they believe poses a danger to themselves or to others. And so law enforcement officer or agency has to file for a risk protection order with the court. And so this is really not something that you could maybe go do on your own, but you can speak with law enforcement about this. They would have to find that there is a danger to themselves or others if this person were to have firearms or ammunition in their control, or to try to limit the purchasing or possessing or receiving of a firearm or ammunition. There's also something called a Chapter 39 injunction, and typically this is for victims of child abuse. And this occurs after a child protective investigation, when the Department of Children and Families, a law enforcement officer, the prosecutor, the state attorney, or another person, or the court, even upon their own motion, may issue an injunction for protection on behalf of a minor child to prevent acts of child abuse. In Florida, we also have another injunction that protects against the exploitation of a vulnerable adult. And this is an emergency protection order to keep an exploiter or a potential exploiter away from a vulnerable adult. And this is usually for seniors. A vulnerable adult is defined as a person over 18 whose ability is somehow impaired due to several factors. This can either be sought by the vulnerable adult themselves, a guardian of the vulnerable adult, a person or organization who is acting on behalf of the vulnerable adult with the consent of that adult or their guardian, somebody who has a durable power of attorney, or a person who's also simultaneously filing a petition to determine incapacity or appointment of the emergency temporary guardian. So at Coast to Coast Legal Aid, we do handle injunctions for protection, and our Family Law and Victims of Crime unit handles those, along with divorces, paternity, holistic legal services for victims of intimate partner violence and human trafficking. We can also help to enforce victims' rights through the criminal cases against their abusers. We have a family court advocacy project at the main courthouse, which is currently closed due to COVID, but people may call 954-355-6216 for assistance, and that number is up on the slide. We also have a senior citizen law project who helps people who are age 60 and older, and they help with health and public benefits, housing issues, foreclosure, defense, naturalization, consumer issues. They also help with elder abuse and exploitation. They have projects to help caregivers age 18 and older who are caring for a senior. They also help grandparents age 55 and older who are taking care of a minor child in their home. We have in each unit economic advocacy and community health, and they help with many public benefits along with other things, but SNAP, TANF, Social Security disability, Social Security income, SSA overpayments, reemployment assistance benefits, healthcare access, Medicaid, Medicare, Affordable Care Act access, and then they also have some special projects to help veterans. For more information, you can always look on our website. We have a lot of more in-depth information, brochures, and applications. You can always call our main number, 954-736-2400. Follow us on social media on this Facebook page. We also have many other legal learning segments about various legal topics that may be of interest to you. And we also try to post them over on YouTube as well. So thank you for joining us today, and have a great day.